Welcome to the Virtual Spring Meeting 2020, brought to you by the American Bar Association Antitrust Law Section. The Spring Meeting is the section's premier event, a multi-day celebration of learning and camaraderie. The Virtual Spring Meeting brings together the world's leading experts on competition, consumer protection, and privacy law, discussing the most compelling issues of the day. Enjoy the show.
Hi, and welcome to Day 5 of the Virtual Spring Meeting. My name is John Roberti. Today we have one of the most popular panels in the entire spring meeting. It is the Enforcers Roundtable. It's an opportunity to hear from enforcers around the world about their priorities and also about the cases that are making headlines. So, without any further ado, let me turn it over to the section chair, Brian Henry. Brian, take it away.
Thanks, John. I'm Brian Henry, chair of the Antitrust Law Section. Also with the Coca-Cola Company here in Atlanta. And yes, if you've seen the news, the rumors are true. As of 7:30 this morning, our bowling alleys and tattoo parlors are open. So if anyone wants to partake, come on down and enjoy. Unfortunately, you can't stay with me. My co-moderator for today is Adam BIEGEL. Adam is co-chair of our virtual spring meeting, and he's with Alston Bird. He is actually also from Atlanta, although he's in Washington now. I don't know, maybe Adam, you can come on down and we can get virtual spring meeting tattoos. But we actually do have cause for celebration because just a few hours ago, we surpassed the 5,000 mark. That is over 5,000 individuals, members, and non-members have partaken in our virtual spring meeting and have either listened to a podcast, watched one of our videos, attended a reception, and we're sure that this session today will take that number even higher. So with that, let's get this program underway. We have very special guests today, the leading lights of antitrust and consumer protection enforcement from various jurisdictions, major jurisdictions around the country, around the world. I want to thank all of them personally for joining in today and being such great sports in doing this program virtually. We would have all been sitting in the Marriott Marquis at this moment in our suits and ties on a formal stage, but we're coming to you from many locations around the world. So with that, our speakers today are Sarah OXENHAM ALLEN. Sarah is the Senior Assistant Attorney General and Antitrust Unit Manager with the Office of the Attorney General in Richmond, Virginia. She is here speaking in her role with the National Association of Attorneys General. Matthew BOSWELL, Commissioner of Competition, Competition Bureau of Canada. He is calling in from Quebec. The Honorable Makan DELRAHIM, Assistant Attorney General, U.S. Department of Justice in Washington. Antitrust Division. Honorable Joe Simons, the chairman of the FTC in Washington, and Margrethe VESTAGER, who actually has, I think, the best title out of anyone, Executive Vice President of the European Commission for a Europe Fit for the Digital Age and Commissioner of Competition. So with that, I'm going to kick this off and going to ask each panelist to start off our program with some introductory remarks and respond to really two questions. One, could you share with us one detail about your experience in working from home over the last several weeks? And then second, commenting on the fact that the global pandemic has touched upon countless government agencies around the world. Could you tell us more about how your agency is responding to the crisis and any related enforcement actions you've taken? So with that, we're going to go for our first round here, go in alphabetical order. Sarah, could you start us off?
Well, thanks, Brian. And first, I want to thank the ABA for inviting me and for putting on this amazing virtual meeting. It's pretty amazing that you pulled this together so quickly and done a great job. Second, I need to issue the standard disclaimer I have, which are any opinions I express here today are mine alone and don't necessarily reflect those of NAG or any particular Attorney General, including my own Attorney General, General Hearing of Virginia. And third, in a fit of madness, last week I cut my own hair, which is probably pretty obvious to everyone watching. And life hack I have for everybody is to not keep your scissors in the bathroom, because every time I go in there, I see another piece that's off and it keeps getting shorter and shorter. So need to walk away from the scissors. But in terms of what the states are doing, as you can imagine, they have been inundated with consumer complaints about price gouging of essential products. Our consumer protection sections are working really hard to keep up with them and to follow up with the appropriate actions. NAGTRI actually operates a public website that is updated daily on the different COVID-19 related actions that the AGs are taking, and you can find that at consumerresources.org. The information there is grouped by enforcement actions taken by the AGs, cease and desist letters that have been issued by the AGs, and multi-state advocacy efforts. Or you can click on each state to see what actions a particular AG has taken. I'd just like to highlight a few state actions. The Ohio AG Yost brought an antitrust and consumer protection action against a man charged with hoarding and price gouging N95 face masks. He sold at least 42 packages of masks on his eBay store at markups of almost 1,800%. The defendant quickly settled with Ohio and will refund more than $15,000 to consumers who purchased masks from him and reimburse Ohio $1,500 of its investigation costs. The defendant also surrendered 570 masks to the AG's office, who has since donated them to a Cleveland health system and to the healthcare professionals who gave the office the tip about his actions. The Missouri AG Smith has also filed for a TRO and preliminary injunction against televangelist Jim Baker and his Morningside Church Productions to stop advertising and selling its silver solution as a treatment for COVID-19. The drug is unapproved by the FDA. And in addition, General Smith has issued several cease and desist letters to companies accused of price gouging. Florida AG Moody has issued more than 40 subpoenas to third-party sellers on Amazon over allegations of price gouging essential commodities. Some of these companies are selling these products for more than 1,600% over the pre-national emergency price. DC AG Racine has also sent cease and desist letters. Some have actually gone to landlords because the district considers undue rent increases during this time to be a form of price gouging. And several other AGs have issued cease and desist letters, scam warnings to consumers, and have signed on to several multi-state advocacy letters to companies and the federal government, including 33 AGs who sent letters to sales platforms like Amazon, eBay, Craigslist, and Facebook. The AGs are urging these companies to take more proactive steps to identify and prevent price gouging, such as developing a pricing system that is triggered as soon as the system detects price spikes on certain products, even before a state of emergency is declared. And the AGs are also urging these companies to develop portals or pages where consumers can report price gouging incidents by third-party sellers on their platforms. And finally, I want to point out a unique COVID-related remedy that Colorado AG Weiser recently announced to settle bid rigging charges with a builder. The company will pay $650,000 to the state, but will also donate construction services of at least that amount, ideally to build a COVID-19 related structure. So those are the highlights of what the states are doing right now.
Thanks, Sarah. Matthew, how are things up in Canada? You don't look like you're at home right now.
I'm not, Brian. Greetings to everybody from Quebec, Canada. I'm in the office today. Come in some days. We have people coming in. Let me also just start by congratulating you, Brian, Adam, the whole ABA leadership and ABA staff for pivoting and putting on the virtual spring meeting so quickly in these difficult circumstances. It's nice to have a semblance of normalcy when we're all dealing with a crazy world. In terms of working from home, for me and for the whole Bureau team, we were able to transition really quickly. Nobody's coming into the office except for some managers. We're operating almost at full capacity and seamlessly. So that's been great. I've been really impressed by the Bureau team picking up the ball and running with it. For me personally, I'm spending way too much time in my basement home office. Spending way too much time using various video conferencing tools, which, when you're like me and you have a face for radio, that's not ideal. But probably the best thing is I get to take my dog, my beautiful golden retriever Bentley, to work with me every day. So that's certainly a silver lining of the whole situation. So in terms of what the Bureau's been doing to assist, I guess, in the response, let me just talk about two things very quickly. First is on the consumer protection side. We rapidly assembled a team dedicated to monitoring social media, monitoring complaints, monitoring the marketplace for false or misleading or just flat out deceptive, fraudulent claims related to COVID-19 and products. They've been working quite quickly to identify these and to take action. We've had multiple different types of claims, claims related to natural products, remedies, foods, all that supposedly help prevent COVID-19. False claims about masks, saying they're actually N95 masks when they're not, and claims about things like filters and air purifiers preventing COVID-19 in your home. So these are dangerous false and misleading representations, and our teams moved quickly to send out warning letters, as I know our colleagues at the FTC have been doing, to get the claims taken down from websites, to get products with those false claims pulled from shelves. We've seen great success in this endeavor. 75% of our warning letters have been responded to. And the second thing we've done really quickly, 2 weeks ago, we issued guidance to the business community in Canada about competitor collaborations, and indicating that we would exercise a greater enforcement discretion for competitor collaborations that are specifically designed to get critical supplies and services to Canadians during this time. But we also said, look, don't use this as a cover for other types of cartel conduct. So we're trying to help, trying to remove any potential chill to collaborations that could assist in the situation. So those are two things I want to flag, and I'm very proud of the Bureau having done.
Thanks, Matthew. Makan, how are things in Washington?
Brian, thanks. And thank you for inviting me and including me in this. And I'll just add my thanks and commendations to what Sarah and Matthew have already said about what the ABA has done to take this virtual and add the, what you guys have done in person online to at least allow for the rest of us in the antitrust profession to continue to learn as we do through the regular ABA process. So things have been interesting in Washington. We probably have been as busy as ever. I've been incredibly proud of the attorneys, the economists, and the paralegals, and the staff of the Antitrust Division for adapting under difficult times and situation that we are all living under. IT has been a challenge, especially with government security and government procurement processes. But everybody is, I think, settling into somewhat of a new normal. Certainly, productivity at some level necessarily has to go down, partly because you just don't have the same interactions you have in the office. I've been going into the office almost every day, as have a few other folks in the front office. Barry is there every single day, and a few of our colleagues, but everybody else is teleworking. in these times. We were informed last week that there was one of our security guards at the main Justice Department building had tested positive. So there's additional precautions. And so I've been going into the office less this past week, and now I'm doing it from home. I think on the personal front, how it's affected me, I was thinking about that. I think there is definitely a silver lining, like Matthew said. One, there's a lot less traffic in Washington. So when I leave the house to go to the office, in the afternoon, what would normally be an hour and a half drive is back down to what is like 25 minutes. And if I can leave at 8:30 and still have that 25-minute commute rather than an hour and 15 minutes, which doesn't require me to leave the house at 7 a.m. I have been able to enjoy my kids. I've got three youngish kids, 5th grade and younger. And so I have been involved. I make breakfast every day for them, and it's been fun. Although the other day, my 6-year-old told my wife that she prefers my breakfast better than hers. And after coronavirus, wants me to continue to cook breakfast for her. So she hasn't learned the art of diplomacy quite yet. But that's been the fun part. How it's affected the division and what has happened to us. Look, our merger reviews and criminal investigations, and that has continued. We're going to have a major announcement next week in a criminal resolution. Folks have been working on as if not to miss a beat. On the merger front, we recently cleared Raytheon and other transactions that continue to go on. We, like Canada, we joined our friends at the Federal Trade Commission, issued some guidance. We wanted to make sure to send a signal to the business community. One, that we're taking this crisis into account, and we are going to do what we can to help with any kind of collaboration that might be needed and review as fast as we can any type of efforts that would be required. I can mention the 2 business review letters. We use our typical business review letter procedures, but we committed to doing those within 7 days. But 2, also say that we're not going to tolerate anybody who is going to transgress the laws to take advantage of this situation, and therefore we have been working, interagency through a COVID, anti-hoarding and fraud task force, as well as through our procurement collusion strike force that we announced last November. And the folks have been quite active on both fronts. And so, our work has gone virtual, but it has continued to proceed on both fronts. Those 2 business review letters, one dealing with the Project Air Bridge under the auspices of FEMA and HHS. I was proud that one, as well as the Amerisourcebergen that dealt with distribution from the National Strategic Stockpile, we were able to get those done within 4 days and 6 days of a review, which, typically some of our business review letters, as some of you will know, can take upwards of 6 months to 9 months, perhaps a year or longer. And to do that, take a Herculean effort of some of our most dedicated and incredible staff, working around the clock and throughout the weekends to get that done. So we have adapted, and we'll see. I think there's going to be some long-term changes, but we've all learned some lessons through this process.
Thanks, Makan. Let's shoot it across town over to Joe. Joe, how are things in your end of the world?
Very good in McLean, Virginia, Brian. Hello, everyone, and thank you for inviting me. And I too want to commend the section for these great virtual efforts. In terms of what I'm doing at home, one thing I noticed about working from our new virtual environment is a change in my wardrobe. I seem to be avoiding any articles of clothing that have buttons. Much more comfortable that way, although today is an exception. On the downside, I really miss the in-person interaction with the FTC staff. I mean, not only are they bright and dedicated to our missions and hardworking, but they're really a lot of fun to be around. So I really miss being around them. In terms of the impact on our work from the COVID crisis, the presence of a health crisis is unfortunately usually viewed by some people, sometimes a lot of people, as an opportunity to take advantage of the public. And so this really makes our mission to protect consumers from anti-competitive and unfair and deceptive acts and practices even the more important. On the consumer protection front, we are prioritizing enforcement efforts to stop coronavirus scams, as well as any attempts to take advantage of consumers' related fears, such as financial distress. To that end, we've sent over 40 warning letters, similar to what Matt Boswell was saying earlier. These went to either companies making unsupported claims about their product's ability to treat coronavirus, or to VoIP service providers and companies that license telephone numbers who facilitate illegal telemarketing or robocalls, including coronavirus-related scam calls. We've also offered an email address, business.covid@ftc.gov, for businesses to seek guidance about the compliance obligations on consumer protection issues during the crisis. And we also offer information to educate consumers about emerging coronavirus scams at ftc.gov/coronavirus. On the competition front, we're, as Makan said, offering to give guidance to businesses through our advisory opinion process on a highly expedited basis, 7 days. And also then on the pre-merger front, our pre-merger filings were done until very recently on a paper basis. We now have made the filing process electronic as a direct result of the pandemic, and the process appears to be working quite well. So I'll stop there, Brian.
Great. Well, thank you. Thanks, Joe. Let's go across the pond. Margrethe, how are things over in your end of the world, Brussels?
Well, it's very good to be with you. I think it's amazing what you have been pulling off to make this virtual. But I must say, I really miss to be with you in person. I think that is one of the things that I have really learned, that yes, you can do a lot of things with technology, but there's nothing that beats being with people. On that note, actually, one of the things I miss is my golden retriever, because I have now been in Brussels for a very long time, while my family and our golden retriever, they are in Copenhagen. And also another practical things, what you have to learn about turning off alerts and notifications, so that your meeting participants doesn't think that you have brought a glockenspiel to work. So let's hope that it will work in these circumstances as well. I completely recognize what you all say. We have 95% of Commission staff, they're working from home. And that, of course, also includes all the DG Comp teams. It's amazing what they have been able to pull off. I really see that they can mirror what you have all been telling. The dedication while caring for kids, worrying about their relatives and friends in other countries, and being at home, having to struggle sometimes with not the most stable connections. Well, one of the things that may be special for us is that we have to deal with how to support companies. That is also one of the things that we do, because we would want to see as many businesses as possible being able to weather the storm, while at the same time maintaining a single market. So a month ago, we put out what we call a temporary framework for state aid rules that deals with things that are connected or related to COVID-19. And they allow for a wide range of and types of support. That be liquidity support to keep business intact, public investment in research on things like vaccines or ventilators. And they allow us to do this very fast. We put it out on the 19th of March. And so far, we have been approving 110 state aid measures in 26 member states, with an estimated budget of 1.8 trillion euros, mostly, but not only through this framework. Of course, there are limits as to what aid can be given, because otherwise we will have no single market, we will have no level playing field, and competition, of course, is still a matter of the heart. So, for instance, loans with the value of more than 800,000 euros can only cover 90% of the loan, the guarantees they're given, so that lenders still have sort of skin in the game, that they can't be completely off the hook. The rules we plan to introduce quite soon will also allow for governments to recapitalize businesses if they have that kind of difficulty. But that would also include incentive to pay back aid as quickly as possible. So we would introduce a ban on dividends and share buybacks, as well as a ban on harming competition by using that aid to buy other companies. As for our merger work, our rules haven't changed, and this crisis certainly shouldn't be a shield to allow for mergers that would hurt consumers and hold back the recovery. What it has done is that it has really put the light on the need of investment to be done fairly. Europe is, of course, open for business, but it shouldn't mean that we leave European companies open for takeovers by others who do not have to play by the same rules. So far as our casework is concerned, we have been able to keep things as close to normal as possible by switching to digital ways, as also Joe mentioned. But in complex merger cases, we also need information, for instance, from customers and competitors who may be busy just surviving, and they don't have much time to provide information for us. And this is why we are asking businesses to consider when they want to file a merger to talk with us in advance, so that we can work out the best possible timing together. But of course, if they have good reasons to notify now, they can still do that, and then we will do everything we can to deal with the merger as quickly and as thoroughly as we do in normal times. In the last 6 weeks, we have concluded 38 merger cases. We have 7 in-depth investigations ongoing. We've had to stop the clock in a couple of them because of lack of information, because the businesses would have troubles in doing that. And maybe last, just a few words on the antitrust work, because here I completely mirror what you have been saying. We've been supporting where there is a public interest of companies coming together to avoid shortages of essential products, could be medicines. And our rules, and I can hear that's the same with you, allows that cooperation as long as it doesn't spill over in illegal collusion or other abuses of the situation. And we are always ready to talk with companies to help them work out solutions that are in line with those rules. And we also recognize that right now, when it's so important to move fast, a more formal type of guidance may be helpful. So we have a temporary framework that explains how to do this when it's COVID-19 related. But we've also given out written guidance in form of a comfort letter, so that a plan to combine data from drug companies to cooperate to increase production and increase supply of vital intensive care medicines in hospitals. And we find that this can actually work quite well. And all of this, of course, and I know that you would share this, we still need competition. It's in the interest of our single market, of consumers, and especially of the many, many people who may not be sure where the next paycheck is coming from. So we want indeed to maintain, because history shows us what a mistake it would be to sort of suspend competition rules. The National Industry Recovery Act, which partially suspended the US antitrust rules after the Great Depression and allowed industries to agree to limit price competition and restrict production. Well, now that seems to be an important factor in slowing the recovery from the depression. And we don't want that unfortunate history to repeat itself, because we really need a bounce back so that people can get the next paycheck.
Great, thank you. Just one more question, a quick one on COVID. I'm sure some of our viewers are wondering, we have a global crisis here. How has COVID impacted the cooperation between your agencies? And with that one, why don't we start with Makan?
Well, thanks, again, Brian. We've had a strong relationship with all of our enforcers partners across the globe, and that those have typically been by phone or video conference. In normal times, the one thing that we miss is that personal interaction at the OECD or what would have been the ICN in a few weeks, and some of the other conferences that we would get to interact, do some either bilaterals or just some informal chats. But the cooperation continues. In our most recent Sabre Fairlogics investigation and litigation that went through and continues on with our friends in the United Kingdom, those communications have continued with the European Commission on some recent transactions in the financial services industry. We continue to work well. And we've learned, I think, from our friends in other agencies. We have discussed and shared our experiences jointly with the FTC, but with some of the other agencies about what we're doing with with their business review letters, with some of the procurement collusion strike force, where that interest has been incoming. And so those communications have continued, but I think we're all in it together, and we have been sharing, I think, our experiences so that we could all benefit from it.
Matthew, any perspective from Canada?
Yeah, I echo what Makan said. At the ICN level, we've been doing a great job of sharing amongst the member agencies different approaches to policies in response to the COVID crisis. On a bilateral basis, Canada is speaking with agencies around the world frequently about their approaches, their thinking on topics, including, of course, agencies represented here today. We've been in close contact with the FTC on deceptive marketing practices that, of course, go across our shared border, sometimes originate here, sometimes originate in the United States, but we're working together to try and tackle those problems. I would say, really, at a high level, the crisis, as terrible as it is, has underscored the strong relationships and actually made them stronger as we rely on each other to get through this and do the best possible job we can in the public interest.
Sarah.
Sorry, I had to unmute. So first, I want to thank the FTC and DOJ for their efforts to reach out and coordinate with the states during this unprecedented time. Makan has contacted the states personally, as have some of his front office staff, and the entire NAG Antitrust Task Force recently had a call with the FTC Bureau of Competition Director Ian Connor and our state liaison Karen Berg about the FTC's recent efforts and how the states can best assist them in antitrust. And in antitrust, the states are basically following the lead of the federal agencies on how to address this crisis right now, and we feel that is the best approach to take rather than trying to forge our own path on this.
All right, thanks, Sarah. I'm actually, given the time and the number of excellent questions we want to cover during this program, I'm going to hand the program over to Adam, who is going to ask a series of questions around merger control.
Thank you, Brian. And I did want to thank you, as well as my co-chair, Brian Gruby, our vice chair, Kelly Kemp, and all of the ABA leadership and staff for helping make this all possible. And also a special thank you to all the enforcers for being willing to take time out of your busy schedules to help us with this. But as Brian said, we did want to have some discussion about some traditional competition and consumer protection topics. So turning to merger control, I had a question for Commissioner Vestager. Competition authorities in the Benelux region, the Politico-Economic Union and formal international intergovernmental cooperation entity between Belgium, the Netherlands, and Luxembourg, and other stakeholders have suggested a move to transaction value-based thresholds to address problems of killer acquisitions or acquisitions of nascent competitors before they can establish a meaningful competitive presence in the marketplace. And you have spoken, Commissioner Vestager, just as recently as yesterday, about the importance of acting early to prevent tech companies from achieving a tipping point to obtain dominance online. Can you tell us a little bit more about what these new tools in the toolkit might be that the EC may be considering in the area of merger enforcement, perhaps including transaction value-based thresholds? And if so, what factors are guiding those considerations?
I can indeed, but maybe let's in two steps and focus on the merger issues first. I'd be more than happy to talk you through some of our considerations about new tools. Because when it comes to mergers, we're not done with our internal reflections yet. We see that we see a lot of smaller companies being bought, not necessarily to be killed, sometimes to be integrated with the buyer. We also see companies that are being created, and someone hope that they will be acquired very often for quite large sums. So we're in an evaluation process to see if we have an enforcement gap. One of the reasons why we find that we have to be careful is, of course, that that it's a significant challenge to predict the evolution of the target absent the merger, because we're talking about smaller companies. So you don't really know what will happen. The counterfactual gets to be tricky because these are young companies. They're in their development stage. They are active in different markets than the acquirer, very often complementary. So for us, we're also trying to figure out, well, how to analyze, how to get sort of full sense of the effect, whether absent the merger, a target will develop from being maybe a fringe player to an effective competitor to the acquirer. And I think it's not an easy question to answer. And even with the widest use of our tools at our disposal, information requests to market participants, internal documents, econometric, quantitative tools, I think it's very important that we are respectful and very careful when we change that, because we want to see the right mergers. We don't want to see thousands and thousands of mergers that just is making red tape, increase I don't know how much. And so far, we have been quite good at relying on referrals because we have this very close cooperation with the national competition authorities in Europe, and that has helped us quite a lot.
The Federal Trade Commission and the Justice Department recently released their long-anticipated draft to the vertical merger guidelines update. Can you tell us a little bit about some of the cases that the agencies were considering, including AT&T, Time Warner, CBS, Aetna, and others, as they drafted and were influenced by in working on the vertical merger guidelines? And perhaps also tell us about some of the timing for the final issuance of those guidelines in light of the second public hearing having to be postponed because of COVID-19.
Sure. Thanks, Adam. So one thing that I learned from the AT&T Time Warner case is that some people actually were suggesting that vertical mergers were essentially per se legal. And for me, that factor really militated very strongly in favor of issuing the new guidelines to make clear that is not the case. When I was the bureau director back a long time ago, we brought 2 or 3 vertical merger cases in a 2-year span. So I definitely believe in vigorous vertical merger enforcement. But we only challenge when the merger is likely to reduce competition. And although that might be less often than with respect to horizontal mergers on average, anti-competitive vertical mergers are not unicorns, and we need to be vigilant in that area. And then in terms of whether these cases in the last year or two have, significantly impacted the vertical merger guidelines, at least from my standpoint. I think that, the last guidelines were out in 1984, an awfully long time ago. There was a seminal article published by Steve Salop and Tom Krattenmaker in the Yale Law Review in 1986, and that laid out an enormous amount of what is in these guidelines today. Of course, there have been increased or an additional developments over time, but I think what's happened is the agencies have been following the guidance from the academic literature for quite a while, and I don't really think that the cases that have come in the last two years or so really involved any kind of a sea change in terms of how we look at it. Again, for me, the biggest thing was I realized that some people are under the impression that vertical mergers are almost per se illegal, and that's just not the case.
Terrific. I wanted to turn to AAG DELRAHIM too. Recent cases like the combination of Sprint T-Mobile and Novellus Aleris have broken new ground for the DOJ. In Sprint T-Mobile, on the challenges of having dual federal state enforcement and amicus advocacy, and the Novellus matter on the novelty of using streamlined arbitration on dispositive issues like mergers. Can you tell us a little bit more about some of the lessons learned and anticipated challenges in these areas?
Sure, thanks, Adam. I think as all of us as antitrust attorneys, we talk a lot about efficiencies in markets, efficiencies of transactions. And I thought it was time for us to turn, at least at the Antitrust Division, for us to turn that lens and look at efficiencies of our processes as well. You mentioned those couple of transactions where I think we were able to manage and turn some efficiencies to benefit American consumers. But also, some of the merger reform, some of the transparency that we announced about a year and a half ago or so about, our process with the hope to get the review process for each transaction, at least so the parties know where we stand and where they stand within 6 months. And we have consistently been able to meet those. Again, that doesn't mean that every transaction fits that mold or that transactions are either terminated or closed after that part, but the parties will know where we stand within that as long as there's that communication. So those two, Sprint T-Mobile and Novellus Aleris were somewhat, unique situations that we are continuing to study and learn from. In Novellus, it was our first arbitration and of a merger case ever. We worked through that. I think, part of that, I think it would be hard to not say that it was animated by some of the judicial decisions recently, particularly in AT&T Time Warner, where I think there was a lot of misguided understanding of what economics is and should be applied in the antitrust cases. So we said, all right, can we, in that case, we were down to one issue between the division and the two parties, the issue of a dispute over market definition. And we thought that was one where it could lend itself. Not a lot of transactions could be that way, where it really comes down to the definition of the market, and then everything else will fall one way or the other after that. So in that particular situation, we were able to come to a mutual agreement on the arbitrator in Kevin Arquette. We were able to have agreements at that time with counsel for Novellus to have limits, to do away with post-trial briefing, to have a certain number of finite days of the trial, to have an answer within, I think it was 10 days or so. And the arbitrator actually beat that time. And, and to do so within a 5-page limit to which he did and explained it. I think the results of that, I would say probably even the parties would agree. One, it provided certainty for the transaction and for the process. We had no idea if we were going to win or lose. We knew we had good evidence, both documentary and economics. But ultimately, it hinged on the documentary evidence, and the analysis was spot on by Kevin. Throughout that process, Dan Wall and his colleagues at Latham, who represented and ably defended that merger, as well as our incredible team who litigated that, we all learned through that process. We probably could have made that process even, we could have taken out probably a third of that process out of the system. We learned, what we can agree to a CMO up front, how else we could make that more efficient. And we have discussed that. And if we were at a normal times, we probably would put on a panel, perhaps at the ABA, with Kevin, with me and some of the litigators, with Dan Wall and some of his folks, about the experience. What did we learn through that? How could we improve that? And how could we use that as a model for the future? Sprint T-Mobile, that was an interesting one. Was glad the way obviously it turned out, but that was one where we were able to see through a major transaction that has big implications, especially as we're seeing in the COVID era, where there's a lot of consumer demand for mobile connectivity. Where there was a transaction there, we got, it was a long investigation, but we were able to negotiate a resolution to that. It involved, about 25 states, both in the investigation, but those who settled with us, then those who challenged us or challenged the transaction in New York State Court. Went through 2 district courts, the procedure. And then multiple, local state utility commissions towards the end. I think we learned a lot about, efficiencies and inefficiencies of our multi-enforcer system in the states. And you had, of course, you also had the Federal Communications Commission involved with that. Now, some of those inefficiencies were created by Congress, and, we have a great dual system of both government and private enforcement in the United States. That is good, but we should also take a look at, make sure that the process is efficient, and those are things we could really learn from the European Union and how the Commission and the national authorities work with each other when they work cooperatively. When the centralized agency, like Margrethe's, preempts the national ones and cooperates with them, when they abstain from reviewing and lets the national authorities investigate. But I think there's a lot we can learn about that. It's just the system we have at the moment. But I was glad, and the filing we made in the court was fully respect and recognize the state's role in enforcing in a merger. However, make sure that a remedy that does not conflict that it wouldn't be in the public interest to have a conflicting remedy imposed through that process, because it would throw the certainty of any transaction out of whack when you have to have 52 plus whacks of the piñata in a transaction.
Thank you. The next question is for AAG Allen. Recently, state attorneys general have stepped up to address national and global mergers that they perceive as harmful to their constituents or overlooked subsets to their constituents. As we mentioned, there was the coalition of state attorneys general that challenged the combination of Sprint and T-Mobile that Virginia was part of. Can you speak to some of the specific challenges faced by state AGs as they seek to protect constituents from potential anti-competitive effects from national and global combinations?
Sure, thanks, Adam. So one of the things this pandemic has shown us is how very connected we all are nationally and globally. And it's very difficult, if not impossible, to contain behavior, either personal behavior or corporate behavior, within a state's boundaries. So now might be a good time to emphasize the strength we bring when there's federal-state coordination. However, our AGs have a duty to the citizens in our states to challenge any competitive harm to consumers in our local or regional markets. And sometimes the only reasonable or efficient fix to that behavior is a national injunction. In T-Mobile Sprint, the litigating states met the presumption of illegality by showing high concentrations post-merger in several local markets. The judge agreed with the states, and in my personal opinion, he did not sufficiently address how the parties overcame that presumption in these local markets. But separate from practical considerations of how to effectively challenge local market mergers apart from national mergers is the fact that a system of multiple antitrust enforcers is precisely the system that Congress set up. And I would commend to you the recent remarks of Colorado AG Weiser for the Loyola Antitrust Colloquium, which was unfortunately canceled, but his remarks were still released, where he noted that the 1976 Hart-Scott-Rodino Antitrust Improvements Act gave the states parens patriae authority to enforce federal antitrust law on behalf of our citizens. Not just state antitrust law, but federal antitrust law. General Weiser placed this within the context of other cooperative federalism regulatory regimes that Congress set up during the 70s, including the Clean Air Act and environmental law as a primary example. In these regimes, the federal government sets the floor or the baseline requirements for enforcement actions, but states are allowed to develop and enforce additional standards. And in 1990, the Supreme Court explicitly recognized the congressional intent of multiple enforcers in California versus American Stores, stating that the ability of states to enforce federal law was in no sense an afterthought, but was an integral part of the congressional plan for protecting competition. And the American Stores case is particularly apt here because it is a merger challenge that California brought after the FTC had negotiated a settlement containing divestitures that would allow the merger to proceed. And in the Microsoft case, several states who were litigating with DOJ were dissatisfied when DOJ settled after the DC Circuit remanded the case on remedies. These states continued the litigation, and the DC Circuit recognized the state's authority to pursue a different view from the federal government. Even when working together, the states quite often negotiate additional relief from the federal government or negotiate separate settlements in order to receive enforcement and notification rights to the obligations imposed on the parties by the settlement. And there are several examples of this even within the last year, including Colorado's additional relief in the United Health DaVita merger that the FTC brought or settled, and the state's additional settlement decrees in DOJ's Nexstar Tribune merger settlement and in the Live Nation consent decree modification. Since Broadcast News versus CBS in 1979, the Supreme Court has recognized that a settlement, even one with a federal agency, does not immunize a defendant from liability. A settlement obtained by the FTC or DOJ doesn't bind the states, but more importantly, it doesn't bind the courts. Courts are the final decision maker for the legality of a merger, as Judge Marrero himself said in the T-Mobile Sprint opinion, where he noted that he was not bound by the conclusions of the FCC or DOJ. He rightfully gave them deference for their subject matter expertise, but he based his decision on his independent analysis of the adequacy of their settlements, rather than on any notion that they represent the national public interest more so than any state. When the states bring an enforcement action, it is presumptively in the public interest, just as when the federal agencies do. States are important enforcers of both state and federal antitrust laws. We fill in the gaps of national enforcement when the federal agencies lack resources or haven't fully developed an area of law, as with our Suboxone product top litigation or the no-poach settlements by the Washington AG's office. We are important identifiers of competitive issues within our jurisdictions, and we may be better positioned or incentivized to consider issues that are not routinely raised in merger challenges, such as potential harm in labor input markets or reductions in services to underserved communities if consolidation occurs. We also bring follow-on civil antitrust cases when DOJ is pursuing criminal cartel enforcement. This is particularly important in the pharmaceutical area, where states are large purchasers of drugs and are uniquely harmed by anti-competitive behavior that raises prices or reduces choice in pharmaceutical drugs to our state purchasers. However, I will end as I began, and to say that consumers are better off when the federal agencies and the states agree and work together. And fortunately, that is almost always the case.
Great.
Well, Sarah, back to you, Brian.
Great. Well, now we're going to address some questions relating to enforcement. Actually, some really interesting questions. We'll start off with Commissioner VESTAGER. The topic is burden shifting. You suggested that dominant firms in the digital economy may become subject to a tougher standard when questioned by enforcement authorities. In particular, the burden actually may be on the dominant firms to show clear efficiency gains rather than on the commission to show harm to consumers. What are some of the dynamics and expected practical impacts in the digital economy that warrant such a significant shift in the burden? How has COVID-19 affected your thinking on these issues, if at all, and has it affected the timing of a possible implementation?
Well, thank you very much. Just to state the obvious, we are, of course, not envisaging any attempt to sidestep our duties under the current framework to prove our cases. That goes without saying. I think it's a very important debate, and it has to be. We have to be very careful about it to avoid misunderstandings, and of course. Also to reduce any kind of overreaction. Because as said, of course, we will prove our cases. But the possibility to rely on rebuttable presumptions is already part of the legal framework and endorsed by the case law to the extent that presumptions are based on solid previous experience. And I think that is important. Think of the test of exclusivity rebates. So it follows that there's no reason of principle to stand in the way of testing new rebuttable presumptions once based on consistent experience. I think that we can safely assume that from a given conduct, anti-competitive effects are likely to follow. But even then, under current rules, presumptions cannot be used. Well, then we have to find ways to enforce the treaty competition provisions in the most effective manner. And besides, it is our statutory duties and it applies at all times. So we have a debate about the standard of proof and we need to have it. And I think that we can safely assume that we have discarded our burden of proof. It is basically about the standard. This is not trivial, though. Many digital markets, they may be prone to tipping, but at the point in time when the relevant anti-competitive conduct takes place, well, the tipping might yet have occurred, or only the first tipping trends may be discernible. If the bar for the requisite standard of proof with respect to anti-competitive conduct is set too high, it may result in under-enforcement to the detriment of consumers. And that is why it's important for competition authorities to be able to intervene once it establishes with sufficient probability that the conduct at issue will likely lead to harm, for example, through foreclosure. The point is that competition authorities should not have to wait until actual detrimental effects on the market can be shown. For example, until companies have exited the market, but should be able to intervene once it's clear, once there is a clear market trend that can be established, which is likely to lead to negative effects on competition. Such safeguards, well, or such interventions can safeguard effective competition in digital markets, and that has been promoted by our European courts, notably with respect to fast-moving and digital markets. To conclude, whilst a reversal of the burden of proof would most likely imply changes in the law, early intervention, which will necessarily have to come with a more prospective analysis of potential effects, might indeed be warranted to prevent tipping in digital markets. So it is to find the right balance between accuracy and administrability without, and that's I will, really underline, without compromising the right of defense. But it's important to be mindful of the risk of abuse of the right of defense to delay, maybe even derail an investigation, and thus reducing or preventing the effectiveness of competition enforcement. So we have to strike the right balance. And striking the right balance is also when we sort of call on the sister of competition law enforcement in a case-by-case way, which is regulation. We have had a lot of considerations, and I think it's a global debate. Because I've been seeing the reports coming from colleagues that I really do respect, to look at what happens in an era of digitization, how effectively to enforce competition law, how to make sure that we have competitive markets. So two things, two observations. First, we would explore the possibility of an ex-ante regulation listing sort of clear-cut prohibitions and obligations for those who may be called digital gatekeepers. And this would tackle commercial imbalances for business actors. We have taken the first step already in what we call the platform to business regulation, which gives the businesses that relies on a platform a set of sort of digital rights. How am I ranked? Why am I ranked? What to do if all of a sudden I'm not ranked anymore? But this would be a step to say, well, these are the obligations that you have if you are a digital gatekeeper. Second, we would also explore sort of a new competition tool. With our enforcement experience and that of other competition authorities that we learn from, as well as this reflection process, I think there is an identification of a number of structural problems that existing rules cannot tackle. That could be monopolization strategies by companies who are non-dominant. Or it could be parallel leveraging strategies by dominant companies in multiple adjacent markets. And these are structural issues, and a new competition tool could allow us to intervene with respect to anti-competitive behavior by powerful but non-dominant players in tipping markets. And this could help us to prevent the creation of future market players with entrenched or dominant gatekeeper positions. And I think the combination of the two to say, well, if you become a digital gatekeeper, you have these obligations, there are these things that you cannot do, and while at the same time having a tool to be able to work structurally in the marketplace to keep it open. It may sound more radical than it is. You probably know how the CMA of the UK, how they have such a market tool. I think that is quite impressive, what they have achieved and how well they use that tool. And I think that's that combination, vigorous enforcements, working with rebuttable presumptions, having a tool to say, well, regulatory, we say if you're a gatekeeper, these are your obligations, these things you cannot do, and having a tool that would allow you to work on the market structure to prevent the market from tipping. because when we have the tipping of markets, well, then we see that we get into a situation where it can be very difficult for consumers to have the full benefit of choice, innovation, affordable prices. So that will be some of the work that we will be pushing ahead in the coming months.
Great, thank you. Commissioner Boswell, the Competition Bureau recently released its 4-year strategic vision, which emphasized a proactive approach towards fostering innovation and competition in the digital economy. Last year, the Bureau also asked the business community to volunteer information regarding strategies certain firms may use to hinder competition in digital market. Are there certain aspects of the digital economy that necessitate a proactive approach? And can you describe some of the tools that are at your disposal to arm that approach?
Thanks, Brian. So as you pointed out, last September 2019, we issued a call out to market participants in Canada for information on potentially anti-competitive conduct in the digital economy. And we really indicated, we had a discussion paper, and we indicated that we were focusing on 4 main areas: online search, social media, display advertising, and online marketplaces. And this was, as you say, a proactive approach, and it's consistent with our vision and sort of shift as an organization to be much more proactive in all aspects of our work and to use all the tools that we have. And this is certainly one of them. So as a result of the call out and over the months that have passed since then, our officers, our case teams have met with multiple stakeholders, large, small industry associations, and have heard from them what's actually going on, how certain things were impacting their business, their ability to compete. And we learned that this proactive approach was really beneficial for enforcement intelligence gathering. We also discovered that many of the smaller tech companies that we encountered were very much focused on their business, and they would develop workarounds to issues that were put in front of them, problems that were giving them resistance. Even if it was anti-competitive conduct or potentially anti-competitive conduct, they just wanted to get on with their business. And in fact, some of these firms were simply not aware of provisions, competition law provisions that could come into play, abuse of dominance being sort of the primary one. So our proactive approach has resulted in more market intelligence that we can pursue, a heightened awareness, certainly with these small tech firms, of competition laws that could be of assistance to them, and also helped internally here to focus the discussion for the Bureau and improved our team's abilities to ask informed questions about very technical aspects of the digital economy. They better understand the intricacies now, and it's going to, it feeds into our enforcement approach. So we're examining all the information we obtained as a result of the call out. As I say, it's informing ongoing investigations. It's also going to assist us in case selection as we move forward. So in terms of the impact of COVID-19, the questions and concerns that we had, and this builds, on comments made by Commissioner Vestager just now, that we had about the digital markets, about the digital economy pre-COVID-19, those continue and are still very much worthy of scrutiny, and perhaps even more so given the dramatic and accelerated movement to digital purchasing as one example. So we'll continue using this approach, this proactive approach, in other sectors of the economy. We'll continue using it in the digital economy. We've seen great value in it. It expands our interaction with the business community at all levels across the country, raises awareness, as I say, and it provides incredible intelligence for our very important enforcement work in this extremely important area of competition law enforcement in Canada and around the world. So it's, I view it as a very positive development, and it shows how when we get out there more, when we use different tools, it enhances our ability to protect consumers and promote competition.
Great, thank you. AAG DELRAHIM. In fall last year, the DOJ launched the Procurement Collusion Strike Force. How has that initiative fared so far, and what should we expect next year?
Thanks, Brian. As you mentioned, last November, I announced, along with a number of our partner agencies, including the investigative agencies, the Federal Bureau of Investigations, Department of Defense, as DCIS, and 13 U.S. attorneys, the creation of the Strike Force. It's an interagency partnership. It was based on a concept that there's a lot of dollars going out at the state, local level, and a lot of procurement that gets out, and some of which might be susceptible to potential bid rigging. So, we wanted to take a look and specifically look at, taxpayer-funded projects at the federal, state, and local level for bid rigging, as well as other related violations that might, other related crimes, that could go along with that. It has been an incredible success. We've had requests in, and one of the biggest challenges is its controlled growth of that to other U.S. attorneys and to other agencies. But we've had over 50 inquiries at different levels of the government about that. They want our advice not only to bring potential allegations of bid rigging that might occur. They want us to help them design procurement systems, to train them. And we designed it to do initially outreach at each level, and to then prosecute any potential crimes that would come, but most importantly, to really deter the type of conduct that might occur through the procurement process. We've already done about 30 different outreach. We've had to adjust with COVID recently, and we've done some virtual trainings. We did one, I believe, yesterday. I know it was this week. It might have been yesterday or Wednesday, and then we have one scheduled for next week. That was to deal with the data scientists and procurement officials to familiarize them with the concepts of antitrust and the types of bid rigging, look for red flags. We had anticipated, somewhere between 75 to 100 would show up. We had over 500 registered, and already an additional 500 registered for next week's state and local agency officials and procurement officials. So it's been, a pleasant success. One of the challenges is resources, of course. Now, the model of this is that we're working with the U.S. attorneys' offices, the local FBI offices, the local postal inspector generals, and a multiple other inspector general offices around the country. And so that's been a full force multiplier, but it has definitely required a lot of resources of our, particularly the criminal sections within the division across the country. We've already opened up a handful of grand juries on those matters as local agencies and contracting officials learn about the types of activity they should be on the lookout. Then they ping us. We developed a whole, both an agency and a citizen complaint center through our website, and that has been quite active. So we anticipate more and more cases. You'll start seeing them, and it's been an important focus for us. I think I've mentioned we've had about a total about 100 grand juries currently, and about a third of them involved government procurement issues.
In the technology sector, what are the guiding principles for how TED is going to investigate relevant conduct? Has COVID impacted this and the timing in any way?
Thanks, Brian. So, although the pandemic has placed a dramatic strain on our country, and particularly certain hotspots, and which include, in particular, where the FTC has offices, I've been incredibly impressed how quickly our staff has adapted to the change in circumstances. They've not missed a beat in continuing to push forward on our investigations, and the pandemic has certainly not stopped our Technology Enforcement Division in pressing forward with its investigations, and nor has it changed the way we think about our enforcement mission. In general, we view things like exclusive dealing, various contracting and licensing restrictions, deceptions, and acquisitions, among other things, as all being on a spectrum of exclusionary practices that could potentially allow a firm to anti-competitively achieve or maintain monopoly power. And in that sense, we think the Microsoft case serves as a very good paradigm for analyzing Section 2 conduct. One recent FTC Section 2 case involved our challenge to Illumina's proposed acquisition of PacBio. Both companies developed next-generation gene sequencing technologies. In the complaint, we alleged that Illumina violated both Section 2 and Section 7 by seeking to acquire its nascent competitor, PacBio. We found Illumina was a monopolist with a 90% share, and it saw PacBio as a looming competitive threat to challenge its monopoly position. The theory that we applied there fits squarely within the Microsoft paradigm. In particular, Microsoft employed a whole set of exclusionary practices that foreclosed nascent competitive threats and harmed the competitive process. Illumina's acquisition represented an extreme version of that kind of conduct. Rather than using exclusive deals and licensing restrictions to hobble nascent competitors, Illumina proposed to take its nascent rival out of the market completely by buying it. So our approach on these monopolization cases that TED is looking at is to a large degree following the DC Circuit's approach in Microsoft.
Terrific. Thank you, Chairman Simons. We want to thank our panelists for agreeing to stay on just a little bit longer to field a few more questions for about another 15 minutes. So we're going to turn now to some consumer protection topics. Commissioner Boswell, first question is for you. How did the Bureau's analysis of big data and competition law affect its understanding of the use of data in deceptive marketing practices?
Thanks, Adam. So yeah, in 2017, the Bureau released a discussion paper on big data and innovation implications for competition policy in Canada, and once again invited public comments, and we engaged with domestic and international stakeholders. Coming out of that, we produced a subsequent document that set out the key themes and some of our learnings as a result of looking into this for competition policy and consumer protection issues. And the subsequent paper addresses big data in all four areas of our enforcement work. But in terms of deceptive marketing practices, obviously we discovered that there could be significant positives with the use of big data to deliver value to consumers, enabling targeted advertising based on their interests, which provides them with relevant, timely, useful information, reducing their search costs, allowing them to make informed decisions. But like anything, there's another side to the coin, and there is significant potential for false and misleading representations, deceptive practices through the use of big data. I guess first, before you even get to the use, it's false or misleading representations about how the data is collected. And this is to promote the supply of a product or service, say false or misleading things about what you're going to do or collect, because data is valuable. Data is significantly valued in the current digital economy. And we are actively enforcing those types of false or misleading representations about the collection of data There's a crossover here, of course, with privacy law, but we believe our provisions in terms of false or misleading representations capture this, and we will bring cases in this area. And then the second half of the equation in terms of big data or data generally is the use of data to create deceptive marketing. Perhaps the best example is, in fact, creating false or misleading data through practices such as astroturfing, which we're seeing around the world, and is a big problem. Something that we've taken action on already here in Canada against a large Canadian corporation, where reviews were being posted, ratings were being posted without disclosing material connections to the actual app that was being reviewed and rated. So this creates data that, very positive reviews, that people rely on this. And as we have more and more online buyers, it was projected there'd be 2 billion online buyers in the world this year. I think it's probably going to go up dramatically given the COVID crisis. People are seeing false and misleading data that then leads them to make purchases. So as I say, we've enforced in that area. We'll continue to enforce in that area. And another, of course, use of data to advance false or misleading marketing schemes is where you're making representations about data prices in the marketplace compared to what your price is. And this is something that we tackled with Amazon. We had a consent agreement with Amazon about some of their representations about pricing, and we'll continue to pay attention to that. So there are lots of issues on the consumer protection side in terms of data and false or misleading representations.
Thank you. The next question is for Chairman Simons. Data protection and privacy concerns are often top of mind with regard to consumer protection. Are there any lessons to learn from the global precedents such as the EU's GDPR or California's Consumer Privacy Act, CCPA, with regard to creating a comprehensive data protection regime?
Sure, Adam. Thanks for the question. So what's going on in Europe and California and other states has clearly sparked significant interest in federal privacy legislation here, and it's still under active supervision or active consideration by the Congress. In my view, such legislation requires very significant societal and cultural value judgments that should be decided by elected officials, not appointed ones. So it really is appropriate, in my view, that Congress take charge in this issue. But having said that, the threat of large fines in GDPR and CCPA seem to have focused the industry's attention on privacy and compliance, which is a good thing. And we've recommended to Congress that any federal privacy legislation be enforced with civil penalties as well. In addition, in GDPR, there is a focus on organizational accountability for privacy, hiring data protection officers, conducting risk assessments, documenting risks, etc. And this focus on creating accountability within companies, particularly large ones that collect a lot of data, is what we have done in our orders. We've strengthened substantive requirements, required greater board or senior level participation in privacy issues, and improved independent oversight generally. Another thing that we can take from GDPR is that if our Congress adopts something remotely close to the GDPR, we at the FTC will require a large increase in resources, at least on par with those of the major DPAs in Europe. They have far greater privacy resources than the FTC. And then the only thing I'll say, which is not directly related to your question, is we had a big day at the FTC today. The court issued the order in Facebook, making it final, so we're really thrilled about that. Thanks, Adam.
Thank you. And we're going to turn it back for one final question back here to Virginia, which is where I'm sitting at home today, for AAG Allen. To build on what Chairman Simons was saying, do you see other states seeing benefits from or expanding upon CCPA and the things we've seen coming from California in terms of privacy?
Thanks, Adam. So California is in the process of finalizing the regulations that will clarify and implement the privacy protections in the CCPA, and they can begin bringing enforcement actions under the Act on July 1st of this year. Although many state legislatures either considered or in the process of considering proposed privacy legislation in their states, only 2 other states, Nevada and Maine, currently have actually passed a consumer data privacy statute. So all states should end up benefiting somewhat from California's Privacy Act because it only applies to larger businesses that are the most likely businesses to have a national footprint. And these companies, I would assume, would find it inefficient to adopt different privacy practices for each state. So it makes sense to comply with California's mandates on a national basis. However, the longer it takes before Congress passes a national privacy statute, the more likely it becomes that companies will have to deal with up to 56 disparate privacy protection requirements for all 50 states and the 6 U.S. territories. However, the Uniform Law Commission is attempting to develop a consensus privacy statute that the rest of the states can accept. And in trying to resolve the conflict between an opt-out standard like, an opt-in standard like in the GDPR or an opt-out standard like in the CCPA, the ULC has suggested a 2-tiered system where consumers can opt out of less sensitive personal information, such as information about things they've bought, websites they've visited, or the probabilistic inferences a company's algorithms develop about a consumer's likes or tendencies. However, a consumer must expressly opt in to the sharing of sensitive personal data, which would reveal racial or ethnic origin, religion, medical data, or any data for a person under age 13. And state AGs would be the primary enforcers of these state privacy statutes. But 2 controversial areas have yet to be resolved. One is the ability of private citizens to enforce the statute, which the CCPA doesn't have at all, and the GDPR only provides a limited private right of action. And the second concerns safe harbors for businesses that are complying with established industry codes of conduct. So if the ULC comes to consensus and recommends a model statute, that may be the best course for consumers and businesses in the wake of Congress's failure to provide a National Privacy Protection Act.
Thank you. Thank you. I wanted to turn it back over to Brian Henry for some concluding remarks.
Great. Well, thanks. And this will conclude our virtual spring meeting Enforcers reception. Sorry about some of the Wi-Fi connections. I'm going to chalk it up to a Friday afternoon and lots of folks getting their online gaming underway. I'm sure that's it. But thanks to our great panelists. This was a fascinating program. Thanks again for pitching in and participating in our program. But for that, we're signing off from virtual spring meeting and reception. Thanks.